Audra with Audra Heller and Associates, and thank you for joining us for Connecting KC with Audra. I started doing these podcasts because of the line of work that we're in and the number of people that we see and questions that we get from friends, family, and clients. So today I am super excited to have our guest, Diana Matienzo. Did I pronounce that right, Diana? I want to make sure
It's
I'm getting
close enough. I answered anything, so I just married into the name.
fabulous. Diana is with Alliance Title and has been our go-to title person that we go to for all of our closings when we sell homes. And Diana has been in the industry for 22 plus years here in Kansas City. She's a Marine, mother of two, dog, and one cat or two cats.
2 cats plus a pregnant cat that just wouldn't leave our house, who just gave birth to 3 kittens.
Okay, so you
So
have
we
a
have
lot
a
more cats
farm.
than I remembered. I did see that on Facebook. So yes, a big family, compassionate, caring, and very knowledgeable. So I wanted to have her join us today because we're getting all sorts of questions, especially with my age being in the 50s. A lot of friends that I know are in the same age group. We're asking about what's going on. What do we need to do to prepare for our family? Because someday I'm going to pass away. What do my parents need to have? And what's all this stuff going on where people can get our deed for our home in their name? So that's one of the things, Diana, I'd like to start out by visiting with you. We're seeing advertisements on TV. We're seeing people, and we're actually hearing a client of mine, their sister in St. Louis, their deed is no longer in their name. How does that happen? And then what can we do to prevent it? Can you talk a little bit today about that, Diana?
So actually, I went to the Kansas Land Title Association conference last month, and this is becoming the #1 white collar crime is deed fraud. So at first we had to worry about wire fraud, and now it's deed fraud. And believe it or not, it's not considered theft yet. So it's not even a felony conviction yet. What we're seeing is it's a lot of land properties that are losing their homes to deeds, or it's going to be rental properties or ones that have been in the family for a long time that really don't have any type of liens against the property. And that's what they're targeting. And
Okay.
unfortunately, in Missouri, we have open records, so anybody can go online and pull information. And with that, they can find out who the current owner is. They can make fake IDs with that information because a lot of people don't check to make sure when they're notarizing documents, they're not taking a black light over it to make sure that it is a valid ID. And we also have notaries that are just notarizing anything because they get paid on the side for it. We actually have notaries whose notary stamps have been recreated and deeds have been notarized using our title agency, like our closers' notary stamps. So there's actually companies that will make these notary stamps and they are notarizing documents and having filed within the public record. What
Wow.
I recommend and what we discussed at KLTA is if you are a property owner, make sure that you look online just to see where your tax bills are going. Because if
Okay.
they do change that address to someone else, then that's why you know that someone has tried to take your property from you with an invalid deed. And unfortunately, when there is deed fraud and it's recorded public record, it's in public record. You just can't take it out because it's bad. We can't redact it. It is in public record. And with that, to get your property back, you have to go through a quiet title suit. And that's not fun because it's going to cost you a couple $1,000s and you can't go back after that criminal to get your property back because you know they're not going to have money or they're just going to change their ID again. So as a property owner, there's so much that you can lose with this, and it's just not fair. And we see that they're targeting elderly people also
Okay.
because they're not really paying attention, or they may be in nursing homes. Sometimes these criminals are looking at obituaries to see if someone has passed on. And if their wife is still alive or their other spouse, they're going to wait for that spouse to die. And then they're going to take care of those properties and put them in their name. We actually had, and I had a real estate attorney that contacted me about a year and a half ago, and she was doing a probate case. And the parents that had both passed on had at least 6 rental properties. And when they were trying to do the probate and get all the things listed for the probate case, 6 of the properties were taken out of their name with fraudulent deeds and put into someone else's name who sold them to someone else. So not only was that original deed that was forged, took that property from them, but now you have someone else who bought that property from the person who received it illegally. And now they're not going to have a place to live because they received stolen property through an invalid deed. Luckily, Platte County has an amazing recorder of deeds, Chris Wright. You guys, please keep reelecting him. He's amazing. He is trying to work with making this a felony conviction, to make it a prison sentence, make it a Class A felony. Because when you think about it, it is theft. You are stealing someone's property.
Yes.
And what he implemented is through their recording system, you can actually register online. And if anyone is to record a deed in your name or any name variation, you'll receive notification from the county saying, hey, this deed was recorded in your name. Is it yours? And it may not be yours. It may be someone with a like name, but
Yeah.
this is the best that they can do, is to say, hey, this is recorded. Is it yours? If not, let us know so we can start investigating, because he is trying to crack down on the deed fraud. He just implemented that if anyone was to come into the recorder of deeds just to record on their own without a title company or an attorney recording it, he's now going to ask for a photo ID. So he's doing whatever he can to prevent that deed fraud. And luckily, Platte County, Clay County, and Cass County all have that same system to where you can go online and register to be notified. Leavenworth County, Kansas also has it. Unfortunately, Jackson County, Kansas, or Missouri, does not have it yet. And that's where a lot of our crime is happening, is in Jackson County. And that's because the recorder of deeds is not an elected official. It's just someone who holds that position of recorder of deeds. So they don't have as much power as an elected official does. And they have two different courthouses people can go down and record at. And they're just, it's a very busy county. So they're just taking deeds and just recording and not verifying anything. And we do our best as title agents when we do our searches is kind of compare signatures to see if they're the same, to see if we can find that, if the deed is invalid.
Yeah.
And lucky, one thing with homeowners, though, when you do purchase a home here in the Kansas City metro area, your seller does purchase an owner's title insurance policy for you. So if there is ever any type of forgery within your chain of title, you are protected by that. That is something that is covered by the owner's title insurance policy if there's any deed fraud in the past. So if there's no way that we can tell if that was an invalid deed, but someone comes back saying, this is my property that was sold, I want it back, that person that owns the home now is covered by that policy. And then you just put a claim into that agent or that underwriter. So they are covered, and that will pay for the suits and stuff like that, your legal fees. So that's one perk about having that owner's policy.
So let me repeat so I make sure I understand you clearly. So one, if I'm purchasing a home and you're my title company or any of the nationwide title companies, part of the title insurance would protect me if there was some shifty with the deed and the people that sold it to me actually didn't own it. Is that correct?
Correct. If you have the owner's title insurance policy, and we're lucky in the Kansas City metro area that our board of realtors has written to the contract that the seller provides that owner's title insurance policy to the buyer. Because in other markets and other states, they have the choice, the buyer has the choice if they want to purchase that policy. And you maybe not have realized this on the closing disclosure, it says optional now for that owner's title insurance policy because it's not a requirement for a buyer to purchase that additional coverage. So we are so grateful here in the KC metro area that our board of realtors understood the importance of that policy to make sure those buyers are protected. Unfortunately, if you're in St. Louis,
Huge.
different story. They have to purchase their own owner's title insurance policy. It is not purchased by the seller. So they have an option. They want to save money at closing. They may waive it.
And so I know because when we do our estimated expense worksheet or for our sellers, we include it and it's based off the price, the final sales price. Is that correct?
Correct. And the coverage, so the coverage is always going to remain the same. So whatever your sales price is, that's the max amount of your owner's policy.
Okay.
So if you purchase a home for $300,000, that's what your policy is going to cover up to.
Okay.
So it doesn't depreciate in value over the years. And it is just a one-time purchase. So once you buy the owner's title insurance policy, it's going to cover you until you sell that home. So it's not like another insurance policy like homeowner's insurance or your car insurance where you're paying every single year. It's just that one-time premium. So I know some people think it's expensive at closing, but you're paying it one time. And look at all the protection that you get for the whole time that you own that property.
Yeah. Since we're talking about that, I want to share a personal example. When my husband and I got married, we both had our own homes. And his home, we went to sell it and found out that there was a line of credit on the home from the previous owner that was never closed out, and there was a balance. So due to this title insurance, they coordinated, got everything closed out. It delayed us a little bit, but in the day, my husband didn't have to pay that money because that was a little bit of a shocker there and things like that. So definitely,
It does cover that.
I'm a huge believer. And luckily, like you said, in Kansas City, it's part of it, which is great.
Right.
One other thing I just wanted to go back to is you said on most of the counties in Kansas City, you can go and register to see if there's any change on the deed or if anyone change of address. Do you just go to the county assessor website? Is that where you go?
It's actually going to be through iCounty.
Okay.
It's a totally different website. So it's where they do the recordings. So that's where everything is held to. And I can give you those links and provide them to you. So if anyone does ask for them, I can provide those to you. Because everyone has a different website. So I just can't say it's iCounty at Platte County. All of them have a different web address. But I would be more than happy to get those for you. And if you are in Leavenworth, Kansas, you can just go into the Recorder of Deeds office and just fill out a form, and they'll make sure that you have that.
Okay. Brilliant. Brilliant.
Kansas really
we'll make
isn't
sure
up
to
to
get
par
this.
yet.
Okay. Perfect. Thank you. Thank you. One of the other things I want to pick your brain on is I had lunch with some good friends of mine, and we were talking about where do you put your house? Is it in the will? The kids are going to get it. It's split 50-50. It's in the will. Well, what about a trust? So walk me through. I've had a couple experiences where a client has had their home in the will. They pass away. If you have a will, do you still go to probate? And again, let me preface first. Diana is not an attorney. This is our little disclaimer. She's not an attorney, but she works with our clients every single day, as well as the top agents in Kansas City. And she has the experience. So, little disclaimer, she's not an attorney. You want to consult legal advice. But Diana, from your end of it, in your title work, what have you seen and what do you recommend or know about, hey, I put my house in my will or I put it in my trust. Can I sell it? Can you close on a house that's just in a will? Maybe we start there.
And the answer is no. It's one of the biggest misconceptions about a will. When people have a will, basically what you're saying is this is what I'm leaving to everyone. It doesn't convey property. It just lists out what your wishes are for all of your belongings, your real estate, any type of financials that you have. So it's just laying out what your wishes are. So it expedites a probate case because then no one has to go to the courts and try to fight over anything when it's already laid out in the will. Where a lot of people think like, well, he's going to leave me the property, so it's automatically mine. Well, you still have to go to court because you never know if someone's going to try to contest that will because they could say, hey, dad wasn't coherent when he filled out this will and you kind of coerced him to do this. And so they could contest it. So they do have to go to probate court to make sure that everything in that will is established and it is given to the correct people. After a death of a person in Missouri, you have 1 year to file that probate. So the faster you get it, the faster you do it, the faster it's going to get done. I recommend that if your home is currently in probate, do not list your property until the personal administrator has been established and the probate is complete. Reason for that is, again, you may have people that come back in and try to, just go against the will, and that's going to delay the probate and it's going to take longer. And if you have a buyer who has a rate lock or is paying all this money for inspections but doesn't want to wait 6 months, you as a seller may be liable for paying back for their inspections because technically you didn't have clear title to convey to that buyer. Because you don't know if the person, if you're the seller, you don't know if you're going to be the rightful owner to sell that property. You may not be the person established by the court to be that personal administrator, but if you're signing a contract stating that you are, and the courts haven't determined that yet, you're really signing a fraudulent contract stating that you have the rights to sell the property when you don't. Now, with that, with the probate, if you have a small estate probate, those really don't take as long. But when you have someone that has a lot of real estate or it has a lot more wealth, those probates do take a lot longer. Just kind of keep that in mind. If you have a small estate, it could take about 2 months. Larger estates, there's no time limit on those. And with that, a lot of people put their properties into a trust.
Yes.
And with the trust, you're able to sell the property within the trust. So whoever is considered the trustees of the trust are those that are going to sign on behalf of the trust or however the trust is written. We do have to review trust to see if we have the correct signers. If any of those original trustees ever resign their position or they die, then it's going to go to the successor trustees. And that successor trustee is going to be the person that is able to sign on behalf of that trust. So as long as you have your trust set up, then you don't have to go to probate because it's already lined up on who can sign on behalf of that trust. So just kind of keep that in mind. And if you ever switch your trust, your successor trustees, you can do that. Just make sure that that is part of your trust. You go back to your attorney to update your trust with that new successor trustee, if that's the case, if you change them.
Okay.
Now we do have what's called non-probate transfers, which is called a beneficiary deed.
Okay.
And so this, if you don't have a trust, if like currently I own my home with my husband. So he and I currently own the home, but if something happens to both of us, and I want to give the property to my son, I can do what's called a beneficiary deed. And what that means is once myself and my husband pass on, then that property is going to automatically go to my son without having to go to probate. All we have to do is put in the public record what the date of our deaths are, and then it's his property to sell. There are different ways that people do set up their beneficiary deeds, and sometimes they don't really think about it beforehand. But let's just say you have 4 children, and your 4 children have that home. And if you put the words in their lineal descendants per stirpes, that means that one of
Say
those
that word
siblings
again. That was a big word.
it's lineal descendants per stirpes. It's a nice little legal Latin word, which
Okay.
basically means it's going to be all those lineal descendants of that person that has interest in that property.
Okay.
So if you have 4 siblings that receive the property through the beneficiary deed, one passes on, then all of their heirs have that 25% interest. So if they have like 10 kids, they all have interest they have that 25% interest. And you have to locate them because they are owners of that property. So you have to have them sign off on that deed. So a lot of people, they have the good intentions of, you know what, I'm going to have my grandkids protected if their mom and dad dies, but they don't realize all the people have to sign. And it's not fun when they're in prison from personal experience because it's not easy to get signatures for that. Just want to throw that out there. One thing to keep in mind is that if you do a beneficiary deed, it does have to be filed of record prior to death. We have a lot of people that have it executed and it's notarized as a proper beneficiary deed, but they never take it to the courthouse. A document is not official unless it's recorded into public record. So even if it's executed and notarized, it has to be within the public records in order for us to accept that as a bona fide beneficiary deed. We have a lot of people that bring him to closing saying, hey, I have the deed, but it's not recorded. So we have to say, I'm sorry, it's going to probate. But if you take that deed with you, saying the intention was to come to me, we didn't record it, then that should expedite the probate.
Absolutely. Well, and we've also had that situation for anyone who's gone through a divorce. You may have a quit claim deed, it's notarized and signed off, but if it was never recorded, it kind of doesn't exist, right? I mean, isn't that an easy way to say it? I mean, they can still take it and have an attorney go get it recorded and we're good. But if it's not recorded, it doesn't count, even if everybody.
It doesn't remove the interest until it's recorded of record.
I think there's so many things that homeowners, we don't realize all of the little ins and outs. And, when people are buying and selling or passing away, there's so many things that need to be taken care of and T's crossed and I's dotted. And that's truly why I wanted to have you kind of come talk to us and go over all of that. Let's talk now. So tax season is right around the corner. So talk to me, Diana, what does a home buyer or seller need to provide to their CPA if they purchased a home last year?
So I'll start with the seller. If you are a seller, take your closing statement or your closing disclosure with you to your CPA or accountant, whoever does your taxes. And with that, you should be able to show like all the different fees to see if anything could be deducted off of there. It also shows proof of taxes that you would have prepaid at closing or that you paid through closing. You should also get a 1098 statement from your lender if you did have a lender when you sold your home. And it's going to show all the interest that you paid on there. So even if you sold that property, you still have a 1098 statement. Even if you didn't pay taxes, there's still going to be interest that you paid throughout the year that you have to take with you. If you're on the buy side, again, take your CD and closing disclosure with you. And you'll also get a 1098 statement from your lender. Keep in mind that if you started out with one lender and they transferred it to another lender for servicing, you're going to need 2 1098 statements. So if that transferred from one lender to the next or another servicer throughout that year, you're going to have to get a 1098 statement for every single person that you paid interest to. And a lot of people don't realize that.
Wow.
And you should get all those by January 31st.
Okay.
If you are a seller that sold your home and you filled out a questionnaire at closing, and if you answered false to any of those questions, you guys should know what I'm talking about if you sold a home, You're
Yeah.
going to get a 1099 in the mail.
Okay.
And also that 1099 is just showing you what your sales price was. If you don't receive a 1099 in the mail, don't freak out because the same information is on your closing statement, your closing disclosure. So if you, even if your accountant says, I need your 1099, you can say, here's my closing statement. It has the same information on here. It's going to show what the sales price is, what taxes I paid, which is what that 1099 is going to show.
Perfect. Wonderful. Super, super helpful. What if they don't have a copy of their closing documents or have not received a 1099? Where do they get that?
Well, if you have an amazing agent like Audra, they send them out at the end of the year because they always have a copy of them. And a lot of real estate agents do this. They like to send out those closing statements at the end of the year just to make sure you get them. Because I'll be honest with you, once we give you those documents at closing, we don't know what you guys do with them, but they're always lost. They get lost in the shuffle. So you can always go back to your agent for that. If you don't feel like bothering your agent, as title companies, we're always at our desk. We live here from 8 to 5. We don't really leave. So it might be a little bit easier for you to contact us and we can always resend those documents out to you also.
Perfect.
Because,
Perfect.
agents are trying to sell houses. They don't have, they're not behind their desk like we are all day.
Well, I'd like to correct you. Last time I checked, you aren't at your desk from 8 to 5. Aren't you there from 8 to 8?
Not anymore. I found balance. After 22 years.
Fabulous. Well, Diana, you have given us so much information, and I'm extremely grateful for you joining us today, sharing the information and knowledge that you have, as well as everything that you do for our clients. We're very, very grateful. You're proactive and always helping and solving problems. Before we close for the day, is there anything else that you want to cover or share with our listeners today?
There's so much I can share because I love teaching people about everything that I know because I have so much in this brain of mine. If you ever have any questions before listing, don't feel that you can't ask questions beforehand. Reach out to the title company or have your agent reach out to us so we can pull preliminary title work just so we can make sure that everything is in place. So what I like to tell agents is once it goes under listing or you have that listing appointment, get that title work pulled. We want to make sure that we're talking to the correct seller. Looking to see who has current titles, like, okay, this person has died. Where is this person? Do you have a death certificate and get everything in place? Just because as a person who has recently lost both parents, luckily our family got along after both parents passed. But there are families that once parents pass, the families fall apart and it's all about money. And so I just recommend that if you think you're going to have a family like that, make sure your parents have everything set up prior to death because it is a very emotional time. And after losing your parents, you're going to have that grief. And then who wants to go through probate? Like who wants to deal with all that and have all that just brought up in court when you're still grieving the loss of your parents or even another family member? So just help them out. I absolutely do recommend if you have older parents to see an elder law attorney. Though they will help out quite a bit. They will help you do all the deeds. They will help out with Medicare, and all that stuff. So you don't have to take care of it and make sure that their estates are properly handled.
Okay.
Just again, because it's not easy to deal with that. And when mom and dad come to the point to where they can't talk anymore because they're incoherent or incapacitated, you're past that time to get things done. So if you have parents that are reaching that age, or if you feel like you can feel some dementia coming on or some cognitive delays, start working on that and getting everything in place because it is going to help you in the long run. And that's just what I recommend. Get those deeds filed. If they have a trust, make sure that you have everything in the trust updated before something happens. If they're going to a nursing home and, they have to have, Medicaid to pay for it. Talk to the elder law attorney to see what has to be done with the property. So then put Medicaid liens against the property. So there's just a lot of things to prepare. And I couldn't recommend an elder law attorney more. Without that, my sister and I would have gray hair or no hair right now because it's not an easy transition. It's very difficult and emotional. But when you have that attorney helping you out, it's going to help out in the long run. That's just my one recommendation.
Super beneficial in knowing that. The other thing I would like to add, just based on the experience that Diana and I've had with other clients, is if you are a power of attorney, it does not mean you are the power of attorney to sign off and sell property. You have to have it specifically stated that you're power of attorney for XYZ Main Street. correct, Diana? Like it has to identify, or for the most part, identify that address so that you can sign off on it, correct?
Well, there's two different types. There's a few different types. There's actually 5 different
Okay.
power of attorneys. So we
Oh,
have your regular
okay, tell me
durable power
more.
of attorney, which is, let's just say you're out of the state and you're not
Okay.
going to be there for closing, then someone can sign on your behalf for closing. Then you have the durable power of attorney that's used by our elderly people or someone that is going to be incapacitated and can't close.
Okay.
And so at that time, you can sign on behalf of that person. But then there's also those durable power of attorneys that state in there that you can't become that power of attorney until that person is incapacitated. That's what's called a springing power of attorney. And
Okay.
I'll have that verbiage in there that those powers don't come into play until that person reaches a certain point. Then that's when
Okay.
they can use that power of attorney. And I actually prefer the springing power of attorneys because that does protect our elderly, because there's a lot of elder abuse that goes on with real estate. Again, because once someone is sick or close to death, they just want money. And I hate to say that, but given the economy right now, people are trying to find any way to get money. And they are kind of preying on our elderly for that, which is another reason why we don't prepare beneficiary deeds as title companies. If you go to the recorder of deeds and ask them for one, they'll say, go to the title company. They're absolutely incorrect with that because it's considered estate planning. So we are not licensed attorneys, so we cannot prepare beneficiary deeds, or if you're in Kansas, transfer upon death deeds. And the reason for that is that we don't want to take on that liability because,
Yeah.
again, you may have someone that coerced mom and dad to sign that deed over to them without discussing with the other family members because maybe they weren't of sound mind. We don't know if we're not there when that deed is signed. So that's why we're going to have an attorney that's going to take on that liability to make sure that they have interviewed those people to make sure that this is what their wishes actually are. And that's why we're going to send you to an attorney. I know it's an additional expense and people think it's a lot easier for us to just prepare them for free, but we cannot do it just because we can be sued for practicing law without a license. And we
Yeah.
don't like lawsuits. We like to prevent
Us
claims,
too.
not create them.
Exactly. Being proactive and making sure you get the best and most knowledgeable people on your side. So no, that makes great sense. Well, fabulous. Well, Diana, thank you so much for joining us today and sharing your wealth of knowledge. We appreciate you, and we will be sure to add in the notes the links and different information. And if you do have any questions, to be able to reach out to Diana. Thank you again for joining us.
Thanks for having me.